All right. Now let us look at chapter 2 of our manual, right? Let's look at chapter 2 of our manual, and that is the formation of a company. Formation of a company. That is covered in chapter 2. So let us look at the learning outcomes of the chapter. So by the end of the chapter, you should be able to know the following. Explain the significance of a promoter in the formation of a company. Explain the duties of a promoter and the remedies for the breach of duty. Discuss the liabilities under the pre-incorporation contracts. Explain the legal effects of certificate of incorporation. So that's what we're supposed to know by the end of this chapter. So let us look at who is a promoter, right? We have come across the term promoter when we are looking at chapter 1, right? In passing, we mentioned the word promoter. But who is a promoter, right? So a promoter is someone who forms a company and performs other tasks necessary for it to begin the business. So this is a promoter. This is the guy behind the idea, right? The mastermind, the person who forms the company. If I have an idea, right, and I go to form a company, then I am a promoter, right? Doesn't mean that it's supposed to be one person, but person or people that form a company and performs everything to make sure that the business or the company is formed or incorporated. That's a promoter, or those are promoters, right? So that's basically the definition of a promoter, right? But a case in Tycross versus Grant, 1977, right? According to Cockburn CJ, that's the judge in that case, right? It was defined as a promoter is one who undertakes to form a company with reference to a given project and to set it going, and who takes the necessary steps to accomplish that purpose. That is basically based on the case Tycross versus Grant. So in the actual exam, they might ask you a question: who is a promoter, or what is a promoter? You might choose to say a promoter is a person, right, who forms a company and performs any task necessary for the company to start, right? That's very okay, right? That's very okay. Or you might say that is a person who undertakes to form a company with reference to a given project and to set it going, and who takes necessary steps to accomplish that purpose, right? All these definitions are okay. But the examiner might specifically say who is a promoter according to the case of Tycross versus Grant. Tycross versus Grant. So if the examiner particularly says that who is a promoter as stated in the case of Tycross versus Grant, then you're obligated to define it as stated, right? As one who undertakes to perform a company or to form a company in reference to a given project and to set it going, and who takes necessary steps to accomplish that purpose. If you are going to say anything other than this, you will miss out on the marks. But whenever they say who is a promoter and the question is open-ended, you can say any definition. That particular just says that is a person who forms the company and takes any steps to make sure that the company has started, right? That's basically it. If you can say something to do with this, that means you are home and dry, right? Home and dry. You can do your own homework to actually know what the Tycross and Grant case is all about, right? But in the manual, they do not what explain it, right? So whenever the manual has not really explained it, it means there's most likelihood that they will never test you to explain what the case is all about, right? So I don't want to make sure to cloud this course explaining what the cases are all about, right? The cases are all about, but you can do your homework, right? But the case is where uh, one of the guys, a promoter, right, actually set out a company, and when he was setting out the company and setting out the prospectus, a prospectus is just basically information about the company that is given to the investors before they actually invest in the company. So what in the prospectus, there was some information that was not what hidden about some contracts. So because of that, people actually bought the shares in the company without knowing about that, right? So later on, they discovered it, so they were seeking remedy. That's basically the case in a nutshell, right? That's the case in a nutshell, right? But you can do your homework, go on the internet and look at what Tycross and Grant is all about. Not particularly important to know the case, right? Because the manual hasn't really explicit. I noticed that when the manual hasn't explicitly explained the details of the case, there's less likelihood that they would ask you to explain the case, right? But what they would want you to say is to reference the case. Just know that in the case, in the definition of a promoter, there's this case, Tycross versus Grant. But maybe another scenario again where they're trying to explain the principle, they might also use this case. So the best you can do is just to say, in this case, right, you can quote the case Tycross versus Grant, right? The principle. That's basically it. But only case where you're supposed to talk about the case in detail is where there's a question say that explain the facts of the case and the ruling. There's some particular cases where they like to do that, right? They like to do that. So that's to do with a promoter. So a person who is acting in a purely professional capacity who have been instructed by a promoter, for example, a lawyer, an accountant, do not become promoters themselves. So what they're trying to say in this particular point, what they're saying is, you are the promoter, right? So we know that when you are actually forming out a company, not just any business, but a company, right? You have to engage professionals like lawyers, accountants to help you, right? So maybe the lawyer will help you form up the memorandum and any other legal things, right? The accountant maybe can help you with their prospectus and so on and so forth. If you are going to engage these guys to help you, right? They are not themselves promoters. Although we're saying that is a person who starts the company and does any necessary steps to make sure that the company starts, these guys are helping to make sure that the company starts, but these guys are not promoters because you have just engaged them, right? You have just engaged them. So them themselves are not promoters. You are the promoter, right? Right. You are the promoter, right? But, right? But if these guys, if these professionals go beyond just you engaging them to do, but they take on responsibilities in the company, like being the directors, the secretary of the company, then they themselves will also be held as promoters. So apart from you just engaging these guys, but you go beyond that and you tell them that you are going to be the company secretary to the company. You are going to be the director to the company. Now, these guys will now become promoters of the company. Now they'll become the promoter. But if you just engage them to help you maybe come up with a memorandum of association, right? It help you to come up with the prospectus and any other financial things, then they are not promoters. But if they go beyond that, they take on responsibilities or they take on roles in the company, like being the company secretaries. That's a lawyer that becomes a company secretary, maybe being the directors in the company. Then they'll be hailed as being promoters of the company, right? Those are principles that you have to be aware of. So let us look at various things that promoters may do. Various things that a promoter in his capacity can do, right? So he may conceive the company and its business. When we say that conceive is just basically he may form, right? He may form the company and its business, right? That's what the promoters do. Form the company and its business. He may find directors of the company. So he might look for directors that will be part and parcel of the company. All right. He may make the statement and its invitation of its shares and debentures. So he will look at the statements, invite people to take on shares in the companies. He might invite people to buy debentures in the company, right? He may pay its preliminary expenses. So because the company has not started out, they don't have money, he might take his own money and pay the preliminary expenses of forming a company, right? Like for any cost maybe that you have to pay to the lawyers, right? You're engaging the lawyers, maybe any expenses to do with paying the registrar of companies and so on and so forth, right? Those preliminary expenses will be incurred by the promoter. He may hold money and property on his behalf. So he can hold money and property on behalf of the company that is yet to be formed, right? He may acquire property for its use after incorporation and enter into transaction for its benefit. So you can see that these are items that the promoter, in his capacity as a promoter, can do. He may engage services of a lawyer or accountants or any other professional advisors. So those are the items that the promoter can do in his capacity as a promoter. So we looked at that he may find directors of a company. So I'm not saying that all directors and all company secretaries are promoters of the company. No. We said that if the promoter has engaged the lawyer, right? This lawyer is basically what? Helping us to form the company. This accountant is helping us to make sure that the company is basically a registered company. But after doing their work as lawyers and accountants, helping the company to be incorporated, then you also give them a role as directors and company secretaries. Then that's where they become company secretaries. And then that's when they become promoters of the company. They have gone beyond just giving services, right? But they have also taken roles in the company. So they have done two things. They have taken role in the company, right, or responsibilities, and they have also helped in the formation of the company. So if they do these two things, then they become promoters, right? They become promoters. But if you just engage a lawyer to help you form the company, an accountant help you form a company, they're not promoters. If you appoint some people as the directors and the company secretaries, they're not. But if they basically do these two things together, then they become promoters. So we can see that what the various things that the promoters can do in case in their capacity as a promoter. Right. So from the foregoing, right, it is seen that there is likelihood of abuse of the promoter, right? We saw in the case of Tycrus, right? I said that the promoter had hidden some important information so that they sell shares to prospective investors, right, or people. So they have hidden what? They have hidden some critical information. So it's like the promoters are abusing their powers. So because there is possibility that the promoters, right, can abuse their powers, right? The Companies Act and the common law have seek to discourage this abuse by the promoters. So, how is the Companies Act? How is the common law trying to discourage, right, promoters abusing their powers, right? What are they doing to stop promoters from abusing their powers, right? We have seen some of the powers that they can do. They can appoint directors. They can hold money for the company. They can enter into contracts, so on and so forth. Those are something that they can do, and that's some things we would say that is their power as promoters. So to make sure that you are not abusing your power as promoters, the Companies Act has actually tried to intervene. So below is a discussion of the legal mechanism preventing abuse of the office of the promoter. So one thing that we should know, right, that the Companies Act and the common law has done to make sure that the office of the promoter is not being abused is basically giving a promoter a duty, right? So the promoter has been given a fiduciary duty, right? Fiduciary duty. Fiduciary duty is just basically a duty of trust, right? A duty of trust. Because of your position as a promoter, it means that you are working on behalf of a company yet to be formed, right? So it's like that people are trusting you to do the right thing, right? So they're trusting you to do the right thing. So a promoter owes a fiduciary duty to the company he is forming, right? It was stated in the case of Enlag versus New Sembroni Phosphate Company, right? That a company is in a fiduciary position to a company which he promotes or causes to come into existence. So in this particular case, Enlaga versus New Sombrero Phosphates, right? This case is the one that is actually highlighting that the promoter has a fiduciary duty to the company. So this case is highlighting that a promoter has a fiduciary duty to the company or has a duty of trust to the company that is forming. So in this particular case, right, we'll see what the facts are, right? What are the facts in this particular case? Right? It has been highlighted in manual, right? It's been highlighted in the manual. So it is basically going to be important for us to understand what this case is all about. So let us now get to understand what is the case all about. So this case, right, is to do with the fiduciary duty of a promoter. So this case, right, this is what happened, right? We know by the format, right, of presentation, it means that this one is the one that is suing, right? Appellant, right? Or the one that is suing, right? And this is the defendant, the one that is being sued, right? So in this case, right, we notice that, right, somebody, right, the promoter and group of people, right, created a company. We would say that a group of people created a company, right? So these are the promoters, right? A syndicate is just basically a number of people, right? A number of people, right? Right? Let's, for example, A, B, and C came together and formed a company, right? Formed a company, right? So these guys, before forming the company, had bought an island where there were mines there, right? Because this phosphate company, Sembrole, was to do with mining. So they bought an island worth 55,000, right? 55,000 pounds. They bought the island long time ago, 1878. It's a very huge money at that time. After buying the island, they try to form this company, right? So subsequently, these guys now formed the company. ABC formed the company. This is called the syndicate, a number of people, right? Formed the company. Now, after forming this company called the New Sombrero, right? After forming the company, the New Sombrero, I'll just call this ABC, right? Formed the company, the New Sombrero, right? Right? But before forming the company, they had bought this island for £55,000, right? Now, after forming this company, this mining company, what they did was they sold this island to the company. They sold this island to the company for 110 pounds. They sold it for 110 pounds. So after selling this land to the company, they did not disclose the profit made by the syndicate on the deal. What they did was they did not disclose how much profit they made, right? Sana auze kuti land anaigula 55, they just kept it from themselves and right ate the money, right? It's not that kutenga ndalama zokunalakika or selling the land to the company was wrong or at this price. But what's wrong is that they failed to be transparent. It's like they were abusing their power. They failed to be transparent, right? They did not disclose about the profits that they made. They made 100% profit, right? That's basically what the case is, right? So that's basically to do with that. So that's where the principle that a promoter owes a fiduciary duty to a company that is forming comes about, right? In that case. Now that we have heard about that case, the ruling was that because they failed to disclose, right? They failed to disclose, right? The promoters were liable, right? Were liable for that, right? They were in the wrong, right? They failed to disclose, right? How much money they made on that. They were in the wrong. They failed to do their duty or comply their duty of trust. Because if they were able to be transparent and disclose their profits, that means their duty of trust should have been held. Right. That's to do with the fiduciary duty, right? So a promoter is prohibited from making secret profit. It's still explaining the fiduciary duty, right? It is prohibited from a promoter from making secret profits, like how they did it. The syndicate made the profit, but did not disclose, right? They did not disclose the profit that they made. So it is prohibiting them from making secret profit. If a promoter makes a profit, right, he must disclose it to an independent board of directors or company existing and future shareholders. So if you make a profit, in this case, right, these guys were supposed to disclose to a company that if it now grows 55,000, right, 55,000, and we have made a profit of 55,000, they have to know. They have to know. They are saying independent because it might be possible that A, B, C might be the board of directors, or they might select a board of directors that they are under their influence. They are saying that they have to disclose this to the shareholders or an independent board of directors, right? An independent board of directors, right? That's being transparent, right? That's being transparent. So I've seen that these guys owe a fiduciary duty, right? This fiduciary duty is prohibiting them from making any secret profit. They have to disclose all profit that they have made to an independent board or future and existing shareholders. Should you fail to do so, right? Should you fail to do so, right? You have failed as promoters to disclose this, then the company has remedies for the breach of your duty. Because you have breached your duty of you have fiduciary duty, right? Or the duty for trust, right? So the company itself has a number of remedies, right? A number of remedies. In terms of remedies, we're just saying that remedies as compensations, sort of like that, right? Compensation or redress, right? Redress, right? For you have done wrong to it, so it's like it's getting compensation for the breach of duty that you have for. So these are the compensation that the company can have, or remedies that the company can have for the breach of duty of trust by the promoter, right? So first thing is that it may compel him to account. So just ask him to tell us how the money has been used, right? And they must disclose everything, right? That's basically in the case of Glusten versus Barnes, right? Barnes. Glusten versus Barnes. So in this particular case, right? In this particular case, this is what is happening. In this case, this is what happened, right? Another syndicate as well, right? A number of people came together, right? And they bought a property, right? Worth 140,000, right? 140,000. Then opened the company and sold these to the company for 180, right? So in effect, the syndicate had made a profit of 20,000, which it did not disclose. So this is what happened. The case in here is not really elaborate, but there's also another syndicate, right? Let's say A, B, C bought a land. They claimed to buy it 140. After forming the company, new company, right? Sold it to what? To new company for 180. And they disclosed the profit of 40. Kuti afa nagula 140 ndipo tapanga profit ya jan ya 40,000. But later on, it was discovered that these guys did not really buy the land for 140. They had bought the land for 120, right? And sold it to these guys for 180 and made a profit of 60. So they had only disclosed the profit of what? 40,000, but failed to disclose the 20,000. So it's like they are making secret profits. They failed to disclose this, right? They failed to disclose this, right? They failed to disclose this. For that reason, it was heard that the syndicate was bound to pay the company the secret profit. So that's being counted, right? Compelling them to account, right? To account for that. And it meant that the syndicate had to basically pay the 20,000 to what? To the company, because they failed to disclose it, right? It's not that, what we're saying is sikuna kuti kwa charge 160, making a profit of 60,000 is wrong, but you have to disclose it, right? If you fail to disclose it, you are breaching your duty of trust. That's the case there, right? And we also know the second case, right? Which is basically Erlang versus New Sembrani. We have discussed that. The second remedy is that the company may rescind the contract or rescind the contract. So we saw in this case, right? What happened is that the company had terminated the contract. Tinaona kuna kuti anagulitsa land for 110, right? So they have the right to terminate. In this case, they were entitled to what? To terminate. If they wanted, they had the right to terminate the contract, right? Ibweze ndrama zatu, this contract has been terminated. It's possible, right? That's a remedy for the breach of duty of trust. That's in the case of Elanga versus New Sembroni phosphate. And last remedy that is there for the breach of duty is that the company may sue the promoter for damages for his fiduciary duty in the case of Tricross and Grant. Right? So there are three remedies that is there. Compel him to account, terminate contract, and sue the promoters for damages. Right? We've seen what Tricross case and Grant is all about. Right? It is where the promoter had hidden some information, right? And Grant was basically an investor in the company, right? And bought the shares. And later on realized that the shares were worthless, right? Because they did not disclose a number of contracts that they were in, right? So it meant that they had paid more for the shares because of what the misrepresentation that the promoters had given. So they had sued these promoters, and Tricross was supposed to pay for the damages. So that's to do with those cases. So those are the three remedies that are there for the breach of duty of trust by the promoter. Right? Let's look at the pre-incorporated contracts. What are these pre-incorporated contracts? And what are the principles behind pre-incorporation contracts? So, apart from breach of the fiduciary duty, a promoter might also be liable because of what is called the pre-incorporation contract. So, what is pre-incorporation? Right? Pre-incorporation contract is basically a contract entered before the company is formed. Right? Let me just say, a contract entered on behalf of a company. Right? A contract entered on behalf, right? On behalf of a company. Let me just rewrite it, right? Is a contract entered on behalf of a company that is yet to be formed. So we can see that it is called pre because the company has not yet been formed, right? So you are entering into a contract on behalf of a company that is yet to be formed. That is a pre-incorporation company. For example, you might, like in the case of Boston, right? We saw that they bought land. Those are basically pre-incorporation contracts, right? So you are buying land on behalf of the company or whatever, right? Those are pre-incorporation contracts. So a contract entered into on behalf of a company not yet formed to procure goods or property which it will need to operate after incorporation. So we have seen these being such, right? These being such. Right, that's a pre-incorporation contract. So what's the principle behind any pre-incorporation contracts? Because there might be some misunderstanding. These are the common misunderstanding with pre-incorporation contracts. So quite commonly, a promoter will have to enter into a contract with a third party on behalf of the proposed company. This is the company that is yet to be formed at a time when the company has not yet been formed. So you are entering into a contract on behalf of a proposed company that is not formed yet with a third party. So it means a promoter, which in this case I'll call A, has entered into a contract with B, right? Right? On behalf of company C. On behalf of company C. But this company has not yet been proposed. This is just a proposed company. So for example, he buys something and he says this is on behalf of company C that is not yet be formed. It's just a proposed company. So that's the scenario that's there, right? So the third party would face a problem in such a situation. If, for instance, the company is subsequently never formed, what happens if the company never formed? Who are you going to sue? Or it was formed, but right just being formed, it is completely liquidated before it has actually paid the amount of money, right? For example, it is now formed, it has been formed, but it has completely been liquidated. Liquidated is just ended. The company has ended, right? Before you have paid B his money. What happens in that case, right? Who are you going to sue? Because if you sue the promoter, right? If you sue the promoter, what he will say, I was just working as a principal of a company. So if you are to sue the company, I was just working as an agent of the company. Sue the company, right? Sue the company. While the company would say that contract was entered before I actually existed. Why sue me? Because that contract was done before I even existed, right? So who do you sue in that case? Right? Who do you sue in that case? So they would have no one to enforce the contract. This is because the promoter would claim only be standing in a position of an agent for the company and therefore not personally liable on the contract. The company would argue that it was not in existence at the time the promoter went into the contract on its behalf. So there's this dilemma that is happening. So it's like the third party will actually lose. Aisa Muganira. Right? Aisa Muganira. So that's why the principle of pre-incorporation contracts came in. So what is the principle saying when it comes to pre-incorporation contracts? So the law must then come out clear on who is liable in such a circumstance so that the innocent party is protected. In this case, the third party, right? B should be protected in such a case. So the law came to intervene, right? To make sure that the third party is protected. So this is what the principle is here. Very important is principles, right? You should understand what the principle is saying. The principle is saying that to begin with, the promoter are not agents of the yet to be formed. Abangadu dispute if a company has not yet been formed, a promoter cannot be an agent of a company that is not formed yet. There's a maxim that says, or a principle that says, a principle in the law of agency says that one cannot be an agent of a person that does not exist. There is a maxim in the law of agency that says one cannot be an agent of a person that does not exist. So completely, if you enter into a pre-incorporation contract, you are not acting as an agent because the company does not exist, right? It means that you are personally liable to such a situation. But, but we should be aware that the company, when it's formed, can now rectify or take aboard the contract or adopt the contract. So the position under Section 45 of the Act is to effect that a pre-incorporation contract can rectify by a company after its incorporation, and if not rectified, cannot bind the company to section 44 subsection of the Act. So what you're saying is, now the maxim or the law is saying that A is not working or is not an agent of a company that is not yet being formed. So it means that in this case, A and B are in contract. Right? Comma company C is formed, right? It can now adopt the contract, right? It can now adopt the contract. Now contract is young, right? If they adopt the contract now, it means that B can sue C. But if the company does not rectify or adopt the contract, it means that the promoter is still liable to A for any breach of the contract. So that's basically it. A promoter cannot be an agent of a company that is not formed yet. But when the company is formed, right, the company can rectify or adopt the contracts. That means the liability has now switched from the promoter to the company. But if it does not rectify the contracts, the liability still lies with the promoter. That's the principle. So in the event that the promoter will be personally liable. So this was said in the case of Nali Farm Limited and Koromani versus National Seed Company. National Seed Company. Let us now look at this case, right? Let us look at this case. In Koromani Limited, with Nali Farm and Koromani and National Seed Company. We can see in this case, we have the appellant, the one that is suing, but we have two people, right? First one and the second one. We have the first appellant, right? Or Osuma, Nali Farm. The second appellant, Koromani. And we have the defendant, the one Aksumiri. So let us now look at the case. So the case is that the second plaintiff, who was the owner of Nali Farm, bought chili seed from the defendant. So tukumona uyu Koromani, that's the second plaintiff, right? Or appellant, is the one that is the only shareholder of this company. Or we can also say that he's the one that formed the company. He's the promoter, right? But before the company started, right, had bought seeds from National Seed Company, right? Subsequently, after Koromani had bought the seed, formed a company called now the Nali Farm Seeds, right? That's the first plaintiff or the first appellant, of which he was the major shareholder and the director, which took over all the assets of the farm. When the seed turned out to be defective and caused losses, the second plaintiff sued the defendant. The issue for the determination of the court was whether the company would sue the contract, and it was heard by Mbalame judge that the company could not sue it as it had not adopted the contract. And in other words, the promoter was the one who could sue and be sued in that contract. So tikuona kuna kuti we have Nali Farm that was formed by Koromani. But Koromani, right, before forming as a company, had entered into a contract with Seedco, right? Seed Company, right? So after entering into the contract, right, then formed this company. Kuna sabe zina kuti anazazindikana kuti the seeds were defective, so they were trying to sue what? They were trying to sue this Seedco company. So anasuma the company that's Nali Farm Limited and Kolomani. All these two people were suing CIDCO. So the debate here was, who is the one that is supposed to sue in this case? Right? So it was heard that because NALIFAM had not yet rectified, rectify contract, or they had not adopted the contract, it meant that Kolomani was the one that was supposed to be what? The one that was supposed to sue. Right? Because it meant that he was the one that is liable to sue or be sued. Because this was a what? Pre-incorporation contract. And NALIFAM did not rectify the what? The case. Right? Or the contract. So in that case, what they're saying is Kolomani was the one that was the rightful plaintiff to sue CIDCO. That's it. And also, let's look at another case, which is basically Zikomo Flowers Limited and versus Financial Bank Malawi. Let's look at another case there. This case is to do with the pre-incorporation contracts as well, right? In this case, they do not actually put down the details, but what we can see from here was that what the judge actually came out. They say that the court mentioned that since the loan created by the promoter on behalf of the company yet to be formed was adopted by the company, the promoter was not liable, but the company itself. So we can see that the Zikomo is a company, and there was a promoter that formed this Zikomo, right? So this Zikomo, before the company was formed, right, went to the bank to borrow money, finance bank. Then formed the company Zikomo Flower Limited, right? After Zikomo had been formed, they had rectified or adopted the contract. So in this case, it was Zikomo that was liable to the case, not the promoter. Because why? Because the company had rectified or adopted the contract, right? So this is basically what we are saying. That's what we are saying in this case. So before we wind up, right, the principle on pre-incorporation, we're saying that a promoter is not an agent of a company not yet formed. So it means that, right? That means he's personally liable, right? But after incorporation, the company can choose, right? Choose to adopt what? To adopt the contract or rectify the contracts. To adopt the contract. In that case, it means that the liability moves from the promoter to the what? To the company. But if they did not rectify the contract, it means that the promoter is still personally liable to that. That's basically the principles there. So let's stop there. Thank you.